Good afternoon. The hearing of the Subcommittee on Intellectual Property Competition and the Internet will come to order, and I'll recognize myself for an opening statement. Today we are holding an oversight hearing on the Obama administration's international IP enforcement efforts, focusing specifically on international patent, trade secret, and market access issues to shine the spotlight on the problems that American companies face when seeking enforcement and using patents overseas. This subcommittee held hearings in April with industry stakeholders and in June with the Deputy Director of the USPTO to look at the patent systems in foreign countries and whether they meet global trading standards. The fundamental question we sought to answer was whether we have a level or an unlevel playing field abroad for American investors. What we learned is that much work needs to be done to level the playing field for American innovators. When American businesses seek to sell their goods abroad, they must be able to compete fairly. Our trading partners must live up to their international obligations and not discriminate against U.S. companies or fields of technology when it comes to patentability and market access. World Trade Organization members are required to make patents available for inventions in all fields of technology. However, many countries discriminate based on the place of invention, field of technology, or whether products are imported or locally produced. For example, countries like Brazil and India limit the scope of patent-eligible subject matter in a way that makes it difficult, if not impossible, for a U.S. innovator to get patent protection. Just as problematic is the flip side, where a country grants many low-quality or junk patents to local companies so that they can sue American companies and get rich quick. Many of these are utility model patents that go through minimal review and lack real inventiveness. Recently, we heard about the Goophone i5, a supposed iPhone 5 clone being manufactured by a Chinese company. This same company also sells a clone of the Samsung Galaxy smartphone. The issue here is that this company has filed for Chinese patents on innovations that were made by others, and this type of patent trolling can be used to threaten American companies and force monetary settlements. For example, Bloomberg reported that in China, of the 530,000 patents granted during the first half of this year, only 107,000 were invention patents. The rest were for design or utility model patents, neither of which requires a rigorous examination process before being approved. We have also seen a series of rulings in Canada that dramatically heightens utility requirements as to the usefulness of an invention, which will result in certain pharmaceutical patents being valid in the U.S. but not in Canada. This directly disadvantages American drug companies and could open the door to other countries that seek to further weaken protections for pharmaceutical patents. Another field where foreign competitors have engaged in protectionist practices is trade secrets. Certain foreign governments have begun adopting policies that undermine trade secrets and disadvantage American companies. These policies include, 1, requiring companies to provide trade secret information to a local partner or government agency as a condition of investment or market access, and 2, testing or certification programs that require companies to disclose confidential information in order to sell their product in the foreign market. When U.S. companies are forced to give their confidential business information to a government authority, there is usually a lack of adequate safeguards to protect it. U.S. companies should not have to choose between treating trade secret theft as simply a cost of doing business and avoiding certain markets in Asia altogether. The issue of trade secret theft is not simply a business-to-business concern. Foreign governments must take these cases seriously and ensure that they have adequate remedies and laws in place. Some countries, like South Korea, China, and India, are looking at using compulsory licensing in the trade secret space. The foreign regulators in these countries can potentially compel new licensing of a trade secret by a third party. This is done to help a local competitor that claims that it needs access to the trade secret in order to compete. What makes this more troubling is that some of these third parties are state-owned enterprises. All of these practices point to the fact that the U.S. needs to be more vigilant in ensuring an international market that is fair to U.S. companies looking to compete. Today, we will examine what the U.S. has and has not been doing to ensure this is indeed the case. Some have argued that the Obama administration has taken a narrow approach when it comes to concerns of American innovative companies in the patents, trade secrets, and market access space. They point to the administration's lack of focus on international patent and trade secret issues generally, as well as the lack of a strong public response when in March the Indian government took the unprecedented step of issuing a compulsory license on a pharmaceutical patent. Trade agreements like the Trans-Pacific Partnership Act, or TPP, provide platforms for the U.S. to exert pressure on other countries to level the playing field when it comes to these issues. It has come to our attention that some provisions being discussed in the TPP, like requirements for plain packaging of tobacco products and pharmaceutical test data protection issues, could weaken rather than strengthen global commitments to intellectual property rights. I look forward to continuing to work to ensure that these negotiations result in stronger, not weaker commitments by other countries to enhance their IP laws. Today, I hope to hear more about the administration's plans to do more to expand the U.S. government's efforts to find real solutions to these unfair trade practices which distort the free market and trade and hinder American job creation. And before we turn to our distinguished witness today, I would be pleased to recognize the ranking member of the subcommittee, the gentleman from North Carolina, Mr. Watt.
Thank you, Chairman Goodlatte. And let me start by thanking you also for accommodating today's witness and me at our previous hearing on this topic in June. As we as members all recognize, there are simply those occasions where you can't be in two places at one time. And both our witness and I had that problem, as I recall, when the hearing was previously scheduled. Be that as it may, I am happy that the Intellectual Property Enforcement Coordinator, Victoria Espinel, is with us here today. Based upon her written submission, it's clear that she has been very busy working to fulfill the requirements of the position conceived by then Chairman Conyers and current Chairman Smith in the Pro-IP Act of 2008. Intellectual Property Enforcement Coordinator handles nationwide and international coordination of intellectual property enforcement efforts. The position has provided an institutional IP enforcement structure to help to ensure that the United States and our IP-intensive industries have a solid economic base in the increasingly competitive global marketplace. In April of this year, the Obama administration issued a report entitled Intellectual Property and the U.S. Economy, Industries in Focus. The report makes plain the value of IP industries to the American economy. These industries produce 27.1 million jobs for our citizens. But as we have seen over the course of this Congress, the foreign threat to American-generated intellectual property is real and ongoing, and in some cases is intensifying. Other countries and their citizens continue to profit from an immense world trade of illicit goods, digital theft, and anti-competitive practices that violate the IP rights of U.S. rights holders. Just this morning, the Congressional International Anti-Piracy Caucus, co-chaired by our Chairman Goodlatte, released a report adding Switzerland and Italy to the list of countries that engage in piracy of American copyrights. So while today we focus on innovation and patent-intensive industries, it's clear that foreign thieves do not discriminate with respect to the type of intellectual property they steal or misappropriate. An emerging threat that I hope we will hear more about in this hearing is the theft of trade secrets of American businesses. In the 2011 annual report to Congress, the IPEC reported that, quote, the pace of foreign economic collection of information and industrial espionage activities against major U.S. corporations is accelerating. Foreign competitors of U.S. corporations with ties to companies owned by foreign governments have increased their efforts to steal trade secret information and intellectual property, close quote. The theft of trade secrets poses a substantial risk, unlike that experienced in the production of low-quality, substandard counterfeits. Trade secrets may enable foreign operatives to duplicate American products and undermine market access. Earlier this year, I was happy to co-sponsor with Chairman Smith's Foreign and Economic Espionage Penalty Enhancement Act of 2012, which I believe will send a clear message that those who dare to steal American trade secrets will pay a heavy price when caught. The bill passed the House in July and awaits action in the Senate. Another area of interest is the impact of the on the U.S. pharmaceutical industry of the successful enforcement efforts noted in Ms. Espinel's written testimony. While our witness rightly emphasizes the public health and safety aspects of these efforts, it would be helpful to hear the impact both from an economic and reputational perspective on the companies whose drugs were copied. Finally, Director Capos, the director of the Patent and Trademark Office, earlier this year testified in essence that litigation within and across American IP industries was a necessary and generally healthy aspect of IP enforcement. I'm interested in the witness's perspective in her capacity as basically the one who herds the cats in how the U.S. IP industries cooperate or don't cooperate in the protection of each other's intellectual property abroad. Specifically, does IP litigation among U.S. companies have an adverse impact on whether they collaborate with government efforts to confront the global threat against intellectual property theft? With that, Mr. Chairman, I'll close. I thank you for holding this hearing again and welcome our witness and look forward to her testimony. I'll yield back.
I thank the gentleman, and without objection, and I don't believe there will be any objection, other members' opening statements will be made a part of the record. We have a very distinguished witness here today, and in light of the fact that we have just one witness here today, we will be more generous than the 5 minutes we ordinarily allow, but we will turn the light on just so you know that how the timing is going on that. And when it turns to red, that signals 5 minutes have expired, but we want to hear your report, Ms. Espinel. And as is the custom of this committee, we swear in our witnesses. So if you would like to stand and be sworn, do you swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you very much, and please join me in welcoming today the Honorable Victoria Espinel, the Intellectual Property Enforcement Coordinator at the Office of Management and Budget in the Executive Office of the President. Ms. Espinel joined OMB in December 2009. Her responsibilities include developing the Obama administration's overall strategy for IP enforcement both at home and abroad. Earlier, Ms. Espinel served in the Office of the U.S. Trade Representative as the Assistant U.S. Trade Representative for Intellectual Property and Innovation. Ms. Espinel received her undergraduate degree from the Georgetown University School of Foreign Service, her law degree from Georgetown University Law School, and a Master of Law degree from the London School of Economics. Welcome, and we're pleased to have your testimony.
Thank you. Chairman Goodlatte, Ranking Member Watt, members of the subcommittee, thank you for your leadership on intellectual property enforcement and for the support that this subcommittee has provided to the administration's overall intellectual property enforcement efforts. There are 3 areas that I will focus on in my remarks today. First, patent enforcement. Second, counterfeit pharmaceuticals. And third, trade secret theft. With respect to patents, last year, in response to growing concerns over China's administrative and judicial systems of patent enforcement, we launched a new initiative to focus on patent enforcement in China. My office and the USPTO have conducted roundtables in Washington, Beijing, Shanghai, and Guangzhou to learn from U.S. companies directly about the specific challenges they face when trying to enforce their patents in China. The goal is to address the deficiencies in China's systems, including the lack of effective discovery, low damage awards, unexamined utility model patents, and the enforceability of judicial orders. With respect to counterfeit pharmaceuticals, because of the very serious risk to health and safety that they pose, combating counterfeit drugs is a critical priority for us. In March of last year, we sent to Congress a strategy that was specifically focused on how we will combat counterfeit drugs. A few examples of our approach include a Customs and Border Protection pilot program that is focused on forming closer partnerships with the pharmaceutical companies to better understand their industry practices and then to leverage that information into more effective and more efficient targeting and enforcement. The effect of CBP's overall prioritization of health and safety is clear, as seizures of counterfeit pharmaceuticals have increased in the last 2 years by nearly 600%. There have been several notable law enforcement operations over the last year. In my written testimony, I highlight several instances of recent joint operations, many of them cross-border operations, that resulted in arrest of individuals that were selling counterfeit drugs and significant seizures. In addition, we have worked with a number of companies from diverse sectors to form a nonprofit group to combat illegal fake online pharmacies, criminals that are masquerading as legitimate pharmacies. The Center for Safe Internet Pharmacies was launched in July of 2012 and is now fully operational. And we hope and expect that CSIP will be particularly effective in reducing the prevalence of counterfeit and illegal pharmaceuticals. On trade secret theft, we have very serious concerns related to the threat that is posed to U.S. innovation from economic espionage and trade secret theft. President Obama and senior administration officials have expressly raised our concerns with China on trade secret theft, and we will continue to raise this as a priority issue and a grave concern. In May, at the most recent Strategic and Economic Dialogue, China agreed for the first time to include protection of trade secrets and agreed to intensify enforcement against trade secret theft. This past year, the Department of Justice and the FBI increased investigations of economic espionage and trade secret theft by 29%. I want to thank Chairman Goodlatte, Chairman Smith, Ranking Member Watt, and many members of the subcommittee for the work that they did in sponsoring the Foreign and Economic Espionage Penalty Enhancement Act of 2012, which recently passed the House. Increasing penalties for economic espionage was one of the recommendations that we made to Congress to strengthen our ability to enforce against this crime, and I thank you for acting on this issue. We are currently in the process of developing a strategy to officially coordinate the government's efforts to mitigate the theft of trade secrets and economic espionage. We need to act aggressively to combat the theft of trade secrets, and I look forward to working with members of this committee as we develop the strategy. Mr. Chairman, intellectual property is used throughout the U.S. economy, and intellectual property rights support innovation and creativity in virtually every sector and every U.S. industry. I look forward to working closely with this subcommittee on improving protection of American intellectual property. Now, I'm happy to take your questions.
And in less than 5 minutes, too. My goodness. Well, thank you very much for that report, and we do have a number of questions, and Mr. Watt and I may go back and forth here in terms of the opportunity to ask lots of questions without going too far. And I hope we're joined by some of our other members of the committee, because this is a very important issue. The administration is currently negotiating a Trans-Pacific Partnership trade agreement that includes provisions dealing directly with the issue of regulatory test data protection and how it should be protected. I understand that although Trade Promotion Authority has expired, the administration continues to negotiate agreements in line with TPA standards, which require the U.S., when in negotiations for a trade agreement, to advocate for standards that are in line with existing U.S. law, which would mean a 12-year term of protection for biologic test data as provided for in the Affordable Care Act. But it appears that when it comes to regulatory test data protection, the administration has instead been working off of a suggestion from the President's budget that calls for a 7-year term. I also understand that as part of the U.S.-China Joint Commission on Commerce and Trade meetings, the issue of a 12-year data protection term was planned on being raised but then taken out and watered down during interagency review to simply push for a generic, quote, new protections, end quote, for biologics. There seems to be a real disconnect here. Regulatory test data is valuable IP, and when countries provide limited or no protection, it would make sense for our negotiators to at least start their negotiations with U.S. law rather than a suggestion made in the President's budget proposal. Can you explain to the committee the importance of data protection, the markets that lack adequate protection, and how you believe it should be protected as a part of the TPP?
So with respect to protection of data protection, this administration, like prior administrations, has made that a priority issue in our trade negotiations. With respect to the specific issue you raised in the term of years, I know that Ambassador Kirk has spoken on that in previous hearings, and I will just repeat that he, the USTR, and the administration as a whole, we stand by U.S. existing law. We also stand by the President's budget. My understanding on this specific issue and the difference of term is that USTR has not, in fact, tabled text on that particular issue yet and is in the process now of talking to a range of stakeholders about the right path there. So I'm happy to take that back to them, but that is my current understanding of the status of that.
Well, let me interrupt there.
Also,
If you stand by both U.S. law and the proposal in the President's budget, there seems to be a conflict between the two. Is there a way to reconcile that?
So as I said, my understanding is that USTR has not tabled text on that because I believe them to be in discussion with the various stakeholders right now about that very issue. On the JCCT and the agenda and the JCCT, that I'm not aware of, but I can certainly look into that and take that back to them.
Thank you. It's crystal clear that many countries have de facto TRIPS violations. And although the President announced a subsidies case while in Ohio on Monday, the administration has failed to bring a single IP case at the WTO in 4 years. The Bush administration filed 24 WTO cases overall, including 2 IP cases and 7 cases against China, despite having a limited amount of time to file since China joined the WTO in 2001, and China's WTO commitments did not become fully operative until 2006. One incredibly powerful tool to help address serious challenges to the economic value of U.S. companies' IPR would be to make use of non-violation nullification and impairment disputes at the WTO. NVNI disputes relate to measures that may not on their face clearly violate any specific TRIPS or other WTO rule, but that nonetheless prevent a member from enjoying the benefits that should accrue to it under the relevant agreement. NVNI measures that harm the economic interests of creative and innovative U.S. companies are prevalent, especially in the area of IP, and they result in significant economic harm to U.S. companies and exporters. And yet there is currently a moratorium on the use of NVNI disputes, and the administration recently agreed to an extension of this moratorium, essentially giving a free pass to China, India, and Brazil on measures that impair U.S. IP interests. Examples of subsidies that could be targeted include preferential or IP-free procurement or subsidy programs that countries such as China have in place, and technical standards that discriminate in favor of locally owned IPR, as well as a range of other preferences accorded to indigenous IPR owners and assets. They could also be used to deal with inadequate enforcement regimes that may implement TRIPS in a manner that impairs the economic interests of right holders. Why has this been allowed to continue, and why hasn't the United States been more aggressive in investigating and in bringing IP cases at the WTO and making use of all of our international trade tools?
So I was at USTR as the Assistant USTR for Intellectual Property and Innovation during the Bush administration when the 2 intellectual property cases were brought against China. So I am personally aware of how much of a priority intellectual property was for the former administration, and I hope it's evident from the work that we've been doing that it's very much a priority for this administration as well. There are a variety of trade tools that we use, and I'm happy to speak to those, but since you really focused on WTO dispute resolution in your remarks, I will focus on that. And one thing that I want to make sure that you're aware of, in case you're not, is that the President announced in the State of the Union and is now up and running to form something called the ITAC, the Interagency Trade and Enforcement Committee. And the ITAC is charged with aggressively investigating potential trade barriers and looking for ways to resolve them using a variety of trade tools, as you said, to bring all of our trade tools to bear, and that includes using our domestic trade law and using WTO dispute resolution. We are very interested in looking for more aggressive ways to resolve the trade barriers that remain. You mentioned, at least in general terms, what might be some specific suggestions for cases that could be brought. I think we'd be very interested in that, and if there's a way for us to have a follow-up conversation, probably best not in an open hearing, about specific suggestions, we would really welcome that.
Thank you. And can you shed any light on the administration apparent recent agreement for an extension of the moratorium on NVNI disputes?
That is not an issue that I've been close to. I'm familiar with nullification and impairment cases as a concept for me at USTR, but I was not aware of the moratorium or the recent extension on that, but that is certainly something that I can look into further.
Yes, if you would, and report back to the committee your thoughts on that and where that's headed, that would be helpful. Next, I'd like to ask about two significant problems that American companies face abroad that center on trade secret theft and patent quality, including weak utility model patents, particularly in foreign markets in Asia, I mentioned in my opening statement. The trade secret theft issue becomes even more troubling when the companies involved may be state-owned enterprises or share significant links with their home government. Trade secret theft is not simply a business-to-business concern, but one that requires real governmental action and legal reform. American companies operating overseas should not have to view this kind of theft as simply a cost of doing business. As part of the Strategic and Economic Dialogue and the U.S.-China Joint Commission on Commerce and Trade, what are the types of commitments that the administration is pushing for to address these pressing problems?
So first, let me say, I absolutely agree with you that this should not be a cost of doing business. It should absolutely not be occurring. And I think we need to move very aggressively to try to stop it, as I referred to in my opening remarks. With respect to trade secret theft, I think there are a number of things that we can do. You mentioned the Strategic and Economic Dialogue, so I'll talk about that specifically, but I think there are a few other things that we can do as well. First, this is a critical issue for us. I think the theft of trade secrets, economic espionage, and the potential impact that it could have on our economy, on our ability to stay competitive globally, is a critical one. So it is very much a front and center issue for us. The President and a range of other very senior administration officials have been raising this with China very directly and very forcefully. And coming out of the most recent Strategic and Economic Dialogue, which was held in May, China for the first time made a commitment to include trade secret theft and to increase enforcement against trade secret theft. So that obviously now our job is to make sure, having had China make that commitment, agree to make that commitment for the first time, to have them actually follow through on that commitment. There are other things that we can do here at home. One of those is to increase our own domestic law enforcement, investigation of trade secret theft to try to stop it before it happens, and then prosecution of trade secret theft after it has happened. In that regard, I want to note again the Foreign Economic Espionage Penalty Enhancement Act. We think that will be very valuable to us in terms of enforcing, so I thank you and other members of this subcommittee that worked on that piece of legislation. And then the last thing that I want to note is that we are right now working internally on developing a strategy focused on trade secret theft and economic espionage specifically, to try to make sure that we are as coordinated as possible and that we are acting as aggressively as we can. And I would very much look forward to working with this committee as we develop that strategy.
Thank you. And one final question. Tying patent rights to domestic manufacturing or actual use in country appears to be the new trick that countries are employing to nullify legally granted patent rights. Brazil and India are countries that require a patentee to, quote, make use of a patent in the country, basically forcing a domestic manufacturing requirement on foreign companies. The Chinese Patent Office has a Made in China requirement requiring inventions that have a tangential link to China be filed in China first or risk losing patent protection. What is the next threat or legal trick that you are just starting to see come up on the horizon? And what can we do about these?
So, as you know, there have been a number of things that other countries including China, have done to try to undermine our innovation in ways that go beyond simply infringement of intellectual property. And you mentioned a few of them. Indigenous innovation was something that we were very concerned about. I believe members of this committee were very concerned about, and China did sort of step back from that when it was raised as an issue of serious concern by the administration. But it is, I think, inevitable that other countries will try to gain an unfair advantage in gaming their system in various ways. And for us, anything that means that our companies have a less stable and predictable environment overseas is an issue of real concern. So whether it's tying things to local manufacture, whether it is, as you said, other tricks that countries are using to try to undermine our innovation in different ways, whatever those issues are, we will continue to try to combat them. Let me take this opportunity, though, to mention one other new commitment that came out of the SNED, which I think is very relevant to this conversation. So in the most recent SNED, China made a commitment to increase sales of legitimate IP-intensive products in status with its, in accordance with its status as a global leader in the economy. And I think that is worth spending a little bit of time on it because of the significance of having China agree to a commitment in those terms. One of the primary reasons that we are concerned about piracy and counterfeiting, that we are concerned about infringement, that we are concerned about other countries gaming their system to undermine innovation is because we truly believe, we collectively truly believe that if our companies have a level and fair playing field, if they have the ability to compete on fair terms, that they will do very well. And so having China make a commitment that will focus, and that will lead to increased exports of U.S. products, that will lead to increased sales of legitimate products. So having China agree to a commitment that is focused on that sort of practical outcome of what we are trying to achieve, I think is very significant, and I wanted to highlight it. That is basically a different way, in addition to all the other things we are doing to try to combat unfair practices that China and other countries raise. That is another way of us going at this issue and trying to make sure that our companies have the ability to compete on fair terms.
Well, given the substantial trade deficit that the United States has with China, if we were to impose a make use of or made in China requirement on the protection of property manufactured in China, and essentially force a domestic manufacturing in the United States, it would have an enormous impact on the Chinese economy, would it not?
I believe it would. I think there are...
I'm not necessarily advocating that. I'd rather see the Chinese back away, but sometimes when you get overwhelmed, the pressure builds on people like members of Congress to, if you can't beat them, join them.
But I think what we're all looking for are ways to get China's attention and make sure that they are taking this seriously. And they have made progress in some areas, but I don't want to overstate that because there's still an enormous problem. What we are looking at doing is looking basically at every point of leverage that we have, at every trade policy tool that we have, and seeing how we can use it most effectively against China. But then also, as I mentioned in that most recent SNED, looking to see if there are other ways to address this rather than sort of just going trade barrier by China and having them sort of step back and make improvements in one area, but then raise new trade barriers in other areas, sort of get at the core of the problem, which is trying to make sure that our companies have the ability to compete fairly and that we're seeing exports and sales of legitimate goods go up in those markets. And that's really one of our primary goals. That's really the core of what we're trying to get at.
Thank you. We'll now turn to the gentleman from North Carolina, Mr. Watt, and he will enjoy the same latitude that he afforded me.
Mr. Chairman, I'm going to exercise my latitude to let Ms. Chu go before me, if it's all right with you.
The gentlewoman from California is recognized for 5 minutes.
Thank you. I actually wanted to follow up on a question that Congressmember Goodlatte asked, and ask about the issue of compulsory licenses, because some countries have been able to use their ability to demand compulsory licenses in ways that I find alarming. For instance, on March 12, 2012, India gave a license to an Indian company to sell a generic version of a patented Bayer drug, even though Bayer had a valid and enforceable Indian patent for the drug. The Indian government justified the compulsory license by stating that the cost was too high and the drug was imported into India as opposed to being manufactured in the country. Some people have opined that compulsory licensing has weakened an intellectual property owner's use of the property. How do you respond to that statement, and what impact do you believe that compulsory licenses have on the effectiveness of international agreements?
So I'm not familiar with the details of that particular case, so I can't speak to that particular case. I can say as a general matter, I believe that countries can and should be able to address the public health situations that they face without taking measures that are going to undermine American intellectual property and American innovation. And that whatever steps they take, they do working closely with U.S. industry. It sounds like U.S. industry wasn't necessarily involved in that case, but that they work with our stakeholders, they work with our companies in a cooperative way.
Okay, well, let me also ask about the Special 301 report. This identifies foreign policies that may unfairly disadvantage U.S. rights holders in other countries. It lists those countries that are deemed to have inadequate intellectual property right protections. What's the significance of this report, and how can it be used to incentivize countries to harmonize their laws to conform to international agreements to which they're a party?
Many countries are unhappy with being listed on the Special 301 list, so it does serve as an incentive for countries to make changes to increase enforcement, or there are other reasons beyond enforcement that countries end up on the Special 301 list. And so it has been a useful tool. I believe in order for it to be effective, it needs to be clear to countries exactly what they need to do to get off of the Special 301 list, or exactly what will place them on the Special 301 list. So one of the things that we've been working with USTR on, and USTR could of course speak to this in more detail, is working with countries that are on the Special 301 list to come up with action plans that make it very clear to them what steps they would need to take to come off of the Special 301 list. And I think because I fear that at least in the past, countries either felt that they didn't know enough of why they were there, or they knew why they were there, but they weren't sure exactly what steps they needed to take to get off. And so I think whether or not that was true or that was simply an excuse they made, I think steps that USTR has been taking to negotiate action plans with countries to make it very clear to them the kinds of improvements the United States would like to see will go far in making the Special 301 list even more effective than it has been. And I think there are a number of instances where it has been quite effective in getting countries to bring their practices more in line with protection of American intellectual property.
In fact, in your testimony, you mentioned that Spain was removed this year after years of placement on that list. What specifically did Spain do to get themselves off the list? What got them on the list, and then what steps did they take to get off?
So I believe Spain was put on the list after my tenure at USTR. So if with your permission, I'd like to go back to them so I can get more details from them about exactly about Spain's placement on the list, and I'd be happy to come back to you on that.
Well, how about, in general, how about the kind of trading best practices that might be able to ensure that people get off the list, that these countries get off the list?
Right, absolutely. So I think there are a number of things that we as a government can do to try to help countries get off the list. Part of that is being clear about what our expectations are. Part of that, as you alluded to, is training and capacity building. And there's a lot that we do now to try to make sure that our training and capacity building is as effective as it can be and is focused on the priorities that we have. And I'd be happy to talk more about sort of the specifics, and USTR can certainly speak more to this as well, the specifics of how action plans are negotiated. I know this past year, when they put the list out at the end of April, they made an open offer to any country that was, for the first time, to any country that was on the list to negotiate an action plan with the United States to try to set up, concrete deliverables so that country would see a path forward to getting off the list. Obviously, our goal is not to have countries on the list. Our goal is to use the list as a way to encourage countries to make improvements in their system.
Are there any one or two concrete examples that you have?
In terms of countries making improvements?
Yeah.
To come off the list? So I'm going to reach back to my time at USTR. So just as one example, I know that we had worked with the government, one example that's relevant to the subject matter of this hearing, we had worked with the government of Hungary because of concerns that we had with their data protection legislation, and they made changes to their data protection legislation, and I understand that the reason why they did that was because of their concern about being placed on the list. I can also, so I know there have been, we have listed in the Special 301 report in the notorious markets list particular markets in China and Russia, and sort of highlighted the level of concern we have about counterfeit and pirated goods being sold in those markets, and that has also apparently motivated increased enforcement against those markets. So those are a couple of specific examples off the top of my head, and I'm going to be happy to go back to USTR and give you a more thorough debrief.
Okay, thank you. I yield back.
I apologize to the subcommittee for my delay. I had two other hearings to attend to simultaneously. Good to have you with us. What are the three key problems that American companies face in China and India regarding patent and trade secret protection, and are they in compliance with their international obligations under the TRIPS agreement?
What are the key problems, and are they in compliance with the TRIPS agreement?
Correct.
So let me speak to the key problems. I'm not the right person to speak to compliance of the TRIPS agreement. So I will put that aside, although I will, as I noted earlier, mention that USTR and the President's International Interagency Trade Enforcement Committee is looking at investigating whether or not there are new ways that we can resolve trade barriers. But putting aside WTO consistency for the moment, certainly patent enforcement, or the deficiencies in patent enforcement in China and trade secret theft are, I believe, a real issue of concern to our companies. And in the last year, we have done, on patent enforcement, as I mentioned, we actually sort of mid-strategy launched a new initiative specifically focused on patent enforcement in China because of concerns that we were hearing from our industry our companies have been trying to enforce their patents in China. They have met with a significant amount of difficulty. There are a range of reasons why they have. So one of the things that we did when we launched this initiative is have a series of sit-down with a wide range of companies in various industry sectors to find out exactly the problems that they were facing in China, and which of those we could try to make progress on. So that is an ongoing effort that we have, but it is coming directly because of our increasing concern about the ability to enforce your patents in China. We also have concerns about the quality of patents in China, which I alluded to earlier. And then with respect to trade secret theft, I could just reiterate my remarks from before, but yes, we are very concerned about trade secret theft. We are very concerned about economic espionage. We are concerned about the impact that will have on our companies and our economy as a whole. There is much that we are already doing to try to combat the theft of trade secrets, but because of the level of concern that we have on trade secret theft, we are at this moment engaged in a process of developing a cross-agency administration strategy focused just on trade secret theft. And as we are in the process of developing it now, we'd be very interested in working with members of this subcommittee as we come up with that strategy.
Thank you I appreciate your response. The distinguished gentleman from North Carolina, Mr. Watt.
Thank you, Mr. Chairman. I'm glad to see you here. Let me deal with two questions that I kind of glossed over in my opening statement first, and then I'll ask one final question, and then I'll let you go, unless somebody else comes and demands your presence. Your testimony talked some about the pharmaceutical industry and the safety, public health and safety aspects of the efforts that we're undertaking. I just wanted to give you an opportunity to talk a little bit about the economic and reputational aspects, implications of the pharmaceutical efforts that we're taking, in addition to the health and safety aspects of it.
So perhaps I will open by saying, when I took this job, and I tried not to have that many preconceived notions when I took it, but when I took this job, my assumption was going to be that there were almost no incidents of counterfeit or substandard drugs coming into the United States, and that the real problem, and it is an enormous problem, was in overseas markets, particularly in Africa, which are really plagued by incredibly high prevalence of counterfeit drugs, and that our efforts would be focused on trying to get more aid to those countries. And that is something that has happened, and we have increased the amount of the State Department budget that's set on aid on those issues. But what I also found out was that we recently have started seeing counterfeit and substandard drugs come into the United States, come to U.S. citizens, because of these fake pharmacies, which are pharmacies in no sense of the word. So we have worked very aggressively to try to combat those fake online pharmacies in a number of ways, which I'm happy to talk about. But I think, to your question on economic impact, I think at least in the United States, given the levels we've seen, this is not an issue that I think is having, at least in terms of the U.S. market, a major economic impact on the pharmaceutical industries. What I think is happening, though, is that you have counterfeit drugs going to U.S. citizens, and even one instance of that happening is too much because of the health and safety risks that they pose. In terms of reputational harm to the industry, that, again, is something that obviously we would like to avoid. But at bottom, our real concern, the real thing that is driving this, is the level of concern of having fake drugs coming into the United States, coming to our citizens, and the risks that that poses for people that are taking them unknowingly.
I also alluded to in my opening statement this question about what impact all of this litigation is having. I take it that to really be effective internationally, we need all hands on board, including the private sector. And one of the concerns a number of people have expressed is that these internal disputes, legal disputes, may be undermining the willingness and aggressiveness of private sector participants in supporting aggressive efforts internationally to protect somebody else's patent and intellectual property. Can you give us some assurance that you're getting full cooperation from our private sector participants in protecting not only their own intellectual property, but protecting the intellectual property of other U.S. companies?
So I heard that in your statement, and I thought it was interesting. I guess I'll say two different things. One is, in terms of the domestic situation, I'm probably not the person best suited to speak to the domestic litigation that is going on, but I will say that we heard a lot when we asked people for input for the next strategy. We heard a lot about escalating litigation costs in the United States, and of course we want to have a patent system here that's working as efficiently as possible, and Director Kapos and others are trying to make sure that happens through implementation of the American Invents Act. In terms of cooperation with other companies, I would say I think by and large we've had good cooperation with other countries. I think we have tried to have an approach that is very inclusive and has as much input as possible from a whole range of companies. And so what I have seen over the last couple of years is a real increase in cooperation. Now, there are clearly areas where I feel like we could have more cooperation, we could have more effective cooperation. So I guess I would say I feel like there is a positive increasing trend, but we are by no means there.
Finally, in a report to Congress in October, there was a suggestion that U.S. technologies and trade secrets face heightened vulnerability to theft in cyberspace. Do you have any recommendations on how we should confront those increasing risks, or do you recognize that that is an increasing risk, as the report seems to suggest?
I think trade secret theft is definitely an increasing risk, whether it happens through cyber or not through cyber. And cyber itself, I think, is also an increasing risk. And that our concern of that increased risk is why, as I mentioned before, we are working on developing this strategy to try to make sure that we as a government are pulled together and as coordinated and as forceful as possible as we can be on that issue. Because, yes, we see it as an increasing concern.
Okay, Mr. Chairman, I think I'll yield back.
I thank the gentleman. I'm told the gentleman from Pennsylvania has no questions. Is that accurate?
That's accurate. I just apologize. I'm trying to get to several committee hearings today.
I too was late as well, so you won't be punished.
And I apologize to Ms. Smedell. I'm very sorry that I wasn't here earlier.
Well, I want to thank the witness for her testimony today. Good to have you with us. Without objection, all members will have 5 legislative days to submit to the chair additional written questions for the witness, which we will forward and ask the witness to respond as promptly as she can so that their answers may be made a part of the record. Without objection, all members will have 5 legislative days to submit any additional materials for inclusion in the record. With that, again, I thank the witness, and this hearing is adjourned.